So before going on the record, we have a few reminders. The hearing will be live streamed. Please silence your cell phones and keyboards. Also, I'd like everybody to check their microphone. So make sure when you push the button, the green light's on.
Green light's on. Can you hear me?
Yes.
Can you hear me from right here?
I see your light's on, but so just check the,
I have the green light on, but then
yes.
but the red light won't go back on. So.
Just push real hard.
Yeah, test.
Okay, great, thank you. All right, looks like we're on the live stream. Good morning and welcome to the Office of Tax Appeals. My name is Kim Wilson, and this hearing is for the appeal of Sales by Schock, doing business as Schock Boats. A stenographer, Ms. Rodriguez, is present and is reporting this hearing verbatim. To ensure we have an accurate record, we ask that each person speak one at a time and avoid speaking over one another. Also speak clearly and loudly when needed. Ms. Rodriguez or any panel member will interject to ensure proper transcription. After the hearing, Ms. Rodriguez will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive, as keeping us on track and creating a clean and efficient hearing record is part of my role as lead panel member. Any questions before we go on the record?
No.
Okay. We are going on the record. This is the appeal of Sales by Schock, Incorporated, doing business as Schock Boats, OTA, case number 230813983. The date is February 19, 2025, and the time is 9:35 a.m. This hearing is being held in Sacramento, California. I am hearing officer Kim Wilson. My co-panelists are administrative law judges Teresa Stanley and Keith Long. We are equal participants in deliberating and determining the outcome of this appeal. I will be the lead for purposes of conducting this hearing. Will the parties identify themselves and who they represent, starting with appellant?
I'm Kai Mickey. I'm president of Sales Tax Specials. I'm here representing Sales by Schock,
Thank
Schock
you.
Boats.
Hi, I'm Kevin Smith. I'm from the CDTFA Legal Division. Thank you.
Jarrett Noble, also with CDTFA.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Thank you. As agreed to the parties at the pre-hearing conference, the direct audit methodology is not in dispute, and the issue to be decided in this appeal is purely a legal question. Whether adjustments are warranted to the manufacturer's rebates to which CDTFA assessed tax. During the pre-hearing conference, neither party raised objections to the other party's submitted exhibits. Therefore, appellant's exhibits 1 through 6 are admitted into evidence, and CDTFA's exhibits A through E are admitted into evidence. Mr. Mickey, you indicated you'd need 15 minutes for your presentation, so please proceed when you're ready.
Okay. Well, thank you, panel members, for the time that we have here to present our case. Our goal and our hope is to show you that the documentation and the facts of this case support that the assessment of the tax on the rebates in question, there's 77,250 total. They're broken up between two individual manufacturers. There's 16 items to Grady White, and there are 7 items to Boston Whaler. Those are the 2 manufacturers. We hope to show you that the assessment of the tax on those is incorrect. I could go back through, I'm going to make this very simple, I hope. I think there's a lot of misinformation and misunderstandings, I hope, by the audit staff and the department. And I'm going to try to avoid all of that, but there are a few points that I'm going to make regarding the decision that I think have incorrectly directed the auditors and the department to make the decisions that they've made. There's 2 types of rebates that are typically in question here. One is a consumer rebate and one is a dealer incentive rebate. And we believe that these are dealer incentive rebates. They are not consumer rebates, and for that matter, Regulation 1671.1 has some provisions in there, which I will talk about in a second, that make it very clear that the facts of this situation dictate that these are not taxable rebates. Little homework, first of all, or a little backstop here. I'm talking to you about Regulation 1671 first, and I trust that we all are aware of 1671.1, but I do want to point out a couple of things anyway, just to make sure. 1671.1 C3A4 is where we are placing our reliance on our determination that these are not taxable rebates. Starting with A, it talks about when a retailer enters into an oral or written contract with a manufacturer or other third party that requires, and this is a big thing, that requires on a transaction-by-transaction basis a specific reduction, again, a specific reduction, very important, in the retailer's selling price of specified products in exchange for a certain payment of a like amount from the contracting party. Such payments received by the retailer are part of taxable gross receipts or sales price of the sales. For the record, we do not dispute that, okay? That's what the regulation says, and we accept that. And if that's what was happening here, we would not be here. But that's not what's happening here, and those are the points that the department, for lack of a better word, are kind of ignoring, in our opinion. It says, for purposes of this subdivision, it is rebuttably presumed that any consideration received by retailers from third parties related to promotions for sales of specified products is subject to tax until the contrary is established. Again, I've been doing this for a long time. I know what the burdens are. We don't dispute that either. We don't dispute that until the contrary is established, these would be taxable, okay? Now, here's where we get into the meat of our position here. The types of documentation that will generally rebut this presumption include, but are not limited to, the following. I don't need to talk about one. There is no copy of an agreement. There is no written or oral agreement in this package, and I'll talk to you about that in a second. Number 2, a copy of an agreement that talks about an advertising allowance. That is not related to this case. A copy of an agreement between the retailer and a third party that provides that the retailer will only receive the payment if the retailer sells a certain quantity of the products. That's not relevant. That's not what happened here. Here's where the relevancy comes into place. And this is the subsection of this regulation that up until now, and hopefully you will change, the audit staff, the department, and everybody else that I've talked to has ignored, in my opinion. And they're just ignoring it because maybe they don't like it, or maybe they are misinterpreting the facts of the situation, which is what I hope the case is, and that's what I hope to clear up. Number 4, in the absence of a written agreement or contract, the retailer may use any verifiable method of establishing that the consideration received from the third party was not subject to tax, such as a signed and dated letter or other type of documentation provided by the third party subsequent to the contract or agreement, verifying that the payment received was not paid pursuant to a contract requiring a reduction in the selling price of specified products on a transaction-by-transaction basis. That is so clear. It is explicit. It's not ambiguous. It point blank tells you that after the fact, in the absence of a written agreement or contract, a letter from the manufacturer that certifies certain things is sufficient to rebut the above presumption, okay? I need you to remember that. I know you know it, but I want to point this out because this is the fundamental point of our position here. Moving on, there is an annotation that addresses the difference between consumer rebates and manufacturer rebates and dealer incentive. I'm not going to address that right now. I don't think it's relevant, although I will point out 295.0948, the second paragraph is explicit to these dealer incentives, and it says that dealer incentives are not taxable, not part of taxable gross receipts. But here's where we're gonna go now. We're gonna go to the two exhibits that we provided, and I will even address the exhibit that the staff got. Exhibit 3 of their decision, it's a Grady Days, August 1st to November 8th, 2016, promotional literature. It's dated July 25th, 2016. I just want to point out that there's nothing in this document that refutes, disputes, it's contrary to, contradicts, or any way, shape, or form says something different than the letter that we got from the manufacturer on 2 occasions as required by Regulation 1671.1. In the DNR, they resort to this as being the sufficient basis. This should override the letter. And you will see that discussion on page 4, starting on page 4 and 5 and 6 of their decision. I could go back through that line by line and reread all that to point that out to you, but I want to make sure you know it's on page 4, 5, and 6, where they essentially determine that this overrides our letters. We say it does not, okay? This does not, number one, this is not the promotion that was in play. It's similar to the promotion that was in play, but it's not the promotion that was in play. Number two, again, there's nothing in here that is contrary to our letters. Number three, there's nothing in this promotional package that says that the retailer must reduce the selling price in order to receive the dealer incentive rebate. So it's simply saying, if you read it the way it is written, it's an invitation to the dealers to participate and receive these dealer incentives, should they choose to do so, by selling the boats. They're not obligated to give the rebate to the consumer. They're not obligated to reduce the selling price in order to get the rebate. They sell a boat, they get the dealer incentive rebate, okay? And that's what this says. So we hold that the document that the state, the department is relying on actually supports our position, okay? Then I'll look at our exhibits. There's 2 of them. There is a January 8th or January 3rd, 2018 letter from Grady White Boats, and there's another September 6, 2022 letter from Grady White Boats that we got subsequent to the first one because we asked Grady White to clarify the couple of points that the auditor disagreed with me about in regards to the first letter. So you can read the first letter dated January 3rd, Exhibit 2, and it's going to say the same thing as Exhibit 4, dated September 6th. But let me point out in September 6th letter the key points here. Remember that 1671.1 says explicitly and plainly that a letter such as this that documents the facts that are necessary is sufficient to overcome the rebuttable presumption. The auditor ignored this, just wrote it off, and you can see in her comments on Audit Schedule 12B2, she says manufacturer's rebates were offered on a transaction-by-transaction basis. Well, okay, so they were periodically on a transaction-by-transaction basis. The dealer, Schock Boats, passed along the dealer incentive rebate to the customer. Okay, so what? On sales contracts, the selling price of a specific model reduced by the amount of the rebate. So what? And sales tax was not computed on the rebate. That is correct, it was not. That's why we're here. So the auditor took parts of what they generally view as being taxable rebates and stopped there. They refused to consider that somewhere along the line, after 2007, October 1st of 2007, somewhere along the line, someone decided that they would change the regulation, go through all the appropriate AOL process, and they provided clarification, if you will, of what type of evidence could be used to overcome what the auditor is saying right here on their 12B2 schedule, okay? So in our letter, it says, on September 26th, on page 2, well, actually on page 1, he talks about they've attached a document, a list of the transactions that qualified for this Grady White promotion, and you will find that these are the 16 boats on Schedule 12B2 that were sold, the Grady White sales. So they're confirming that the transactions in the audit on 12B2 were covered by the promotion that they're addressing in this letter that we got pursuant to 1671.1. They go on to say, and these are the key points, in paragraph 2, on the second page, it says Grady White Boats has no control over the selling price offered by the dealer. Additionally, the selling price of the boat has no impact on the receipt by the dealer for any promotional allowance. Paragraph 3, third line down. Dealers are not required to reduce the selling price of the boat in order to secure the promotional allowance. Although the promotion is available for the consumer, dealers are not required to extend it to them. Then in the last sentence, it is possible for a consumer to buy a boat without the knowledge of the promotion in process. These are dealer incentives. These are not consumer manufactured. That's my phone. I'm sorry. I turned it off. I don't know why it's still going off. I'm trying to ignore it. Sorry. So our letter clearly states and certifies, pursuant to 1671.1, the requirements to establish that these are not taxable rebates. And up until this point, this letter is simply being ignored. Now, I would like to believe that if everyone knew that these facts were the case, we would not be here. My presumption is that along the line here, up until now, everybody at the state, CDTFA, is just simply ignoring the fact that this letter should be sufficient to overcome the presumption, directly in conflict to what the regulation says. And that's why I mentioned in the pre-hearing conference that the point of this is really a legal argument. We have the letter that certifies that all the facts are specifically correct to make these non-taxable rebates. The question is whether the state can ignore the section C3A4. Can the department choose to ignore what that section says? If you determine that they can ignore that section, then I lose. If you determine that the state, the CDTFA, does not have the authority to disregard what their own regulation states because they don't like what it says, are not used to what it says, it may not be exactly like they might do other things, then we win. Can they ignore it? I lose. Can they not ignore it? We win. And that's our case.
Thank you.
Thank you. Thank you.
Judge Lung, do you have any questions?
I'll hold my questions for now. Thank you.
Judge Stanley? I don't have any questions at this time. Okay, I don't have any questions either. Okay. Mr. Smith, you indicated you'd need 15 minutes for your presentation.
Correct.
You may begin when you are ready.
Thank you. Good morning. At issue today is whether an adjustment is warranted to appellant's unreported taxable rebates from boat manufacturers. Appellant operates a vessel dealership in Newport Beach, California, from which it sells boats, boat engines, trailers, and accessories. As relevant to this appeal, during the liability period, appellant received $77,250 in rebate payments. Sorry, $77,250 in rebate payments from two boat manufacturers, Grady White Boats and Boston Whaler, which appellant did not report on its sales and use tax returns. The rebates consisted of 23 payments ranging from $500 to $8,500 that were issued to appellant for sales of vessels that are made to customers during various national sales events offered by the two manufacturers. Upon audit, the department examined appellant's sales contracts and found that they included various manufacturer rebates, and that appellant had reduced the selling price of the boats to the purchaser by the applicable rebate amount. The department determined that appellant collected and remitted sales tax reimbursement based upon the adjusted selling price of each boat to the purchaser, but did not report or collect sales tax reimbursement on the rebate amounts that it received from the manufacturers. The department determined that the measure of tax should include amounts received by the retailer, and that the rebates at issue were subject to tax. California imposes sales tax on a retailer's retail sales in the state of tangible personal property, measured by the retailer's gross receipts, unless the sale is specifically exempt or excluded from taxation by statute. All of a retailer's gross receipts are presumed subject to tax unless the retailer can prove otherwise. Gross receipts means the total amount of the sale, valued in money, whether received in money or other value. Regulation 1637.1, subdivision C3A, provides that when a retailer enters into an oral or written contract with a manufacturer or other third party that requires, on a transaction-by-transaction basis, a specific reduction in the retailer's selling price of specified products in exchange for a payment of a like amount from the contracting party, such payment received by the retailer is part of the taxable gross receipts or sales price of the sale. Here, initially, we note that appellant has not provided any documentation regarding the rebates it received from Boston Whaler, and thus no adjustments should be made to those amounts. Turning to the Grady White sales, the July 25th, 2016 promotional announcement, which is part of Exhibit A, shows that Grady White notified appellant of the Grady Days promotion and instructed appellant to use the promotional allowance on its sales. Grady White also told appellant that it would advertise the event nationwide and recommended that appellant advertise the event locally to complement its national campaign. Appellant then sold the Grady White boats at issue during the relevant promotional events advertised nationally by Grady White and reduced the selling price of the boats by the promotional amounts. It then received the applicable rebates from Grady White for the boats sold. To be specific, the available evidence shows that appellant reduced the selling price of the boats to his customer and received payments from Grady White for the same amounts. This establishes that appellant agreed to reduce the selling price of the boats on a transaction-by-transaction basis, based upon the rebate amount offered by Grady White, in exchange for the payment of a like amount in the form of a rebate offered by Grady White. This is similar to the situation discussed in annotation 295.0948, where manufacturers' rebates are considered taxable as an inducement to the purchaser because they were a reduction in the selling price provided directly to consumers and thus part of gross receipts. In other words, the evidence indicates that appellant received consideration for the full retail value of the boats. It did not receive a discount on its cost from the manufacturer. Although appellant has submitted letters from Grady White stating the contrary, these letters were sent after the audit period, and the statements are contrary to the documentation discussed previously. Thus, the rebates from Grady White at issue are subject to tax, and no adjustments are warranted. This concludes my presentation. Thank you.
If I could just add one thing. Sorry, my internet went out. I was looking up the citation on my phone. 1671.1, I believe it's D4F, contains an example addressing written letters by manufacturers to rebut the presumption at issue in this appeal. And in that example, they note that there were no concerns with the letter, and therefore it was accepted. As was discussed in the decision, the supplemental decision, and our briefing, we think the evidence here is contrary to what the letter says. I just want to make it clear that the reg does address something like that, and we have discussed it in the prior briefings. Thank you.
Thank you. Keith, Judge Long, any questions?
No questions, thank you.
Judge Stanley?
I don't have any questions.
Okay. I don't have any questions either. Let's turn back to Mr. Mickey. You have, if you'd like to make a rebuttal argument, go ahead.
Yes, please, thank you. The last point, whatever section he's referring to that allows him to disregard the letters based on not accepting the factual basis of the letters, and he says that they're in the DNR or the decision that was addressed. The way it was addressed in the decision, as I pointed out and acknowledged, is that they looked at this Grady White's promotional literature here as the supporting document for their position there. They have nothing else, so it has to be this. Okay, number one, this is not the actual promotion for the promotions that were in effect during this time, like I said, and we acknowledge it's similar to it. And nothing in this document says that the dealer was required to reduce the selling price. We are not disputing that the selling prices were reduced. We're not disputing that they received the rebate. What's at dispute is that we are proving to you through the letters that cannot be contradicted by any information that the staff has, that the dealer was not required to reduce the selling price. That's what the letter states in order to receive this rebate. Secondly, another point was made that these letters were gathered after the audit period. That's because the issue came about and questioned by the auditor. And so as in 1671, C3A4 that we're citing, it talks about being able to receive these letters subsequent to the contract or agreement. So once again, the department wants to say that they had to have them at the time. They can't get them after the contract. That's the whole point of the letter, is to get it when there isn't an agreement, and you get it after the fact, after the contract or agreement. It's what it says in the regulation. So the regulation says we can get it subsequent. The department wants to say we got it subsequent, so it can't be accepted. That doesn't make any sense. They're ignoring what the statutory language of their own regulation is. We're not disputing the fact that these rebates existed. Very clear. We're not disputing that the rebates were applied to the sales. We're not disputing any of that. And yes, they got the money back from the manufacturer. We're disputing the fact that they were not required to reduce the selling price. This document that they rely on says nothing about that. In fact, it says contrary. It just talks about, hey, if you do this, send in the warranty registration, we'll give you the money back. They're not talking to anything to the dealers about having to reduce the selling price on a transaction-by-transaction basis. There's no contract. So because there's no contract or written agreement, because they're just saying, do it if you want. These are the terms, you do it. If you don't do it, we send you money. Then we get the letter that the regulation says, and the staff wants to say, or the department wants to say, they can't accept the letter because they got this proof right here. This is no proof of anything. I don't know what else to say about that. I don't know how else I can do that. It is addressed in the DNR and the decision, and that's the point that I wasn't going to read that starts on page 4, 5, and 6. That's exactly what the decision did. They said that they couldn't accept the letter because the other documentation evidence was stronger. Well, if we want to get into preponderance of evidence and all those things, this letter This letter satisfies by more than preponderance of the evidence, it's clear and convincing, that the statutory requirements of 1671 regarding these rebates has been satisfied as to these rebates are not taxable rebates. I don't know what else to say. I hope that as a panel on this, I hope that you will be able to see the difference between their supporting document, so-called, and our letter, and then look at what the statutory language says about the validity of our letter and recognize that the point and the purpose and the reason for that regulation was exactly to avoid things like this right here, where we're here today. In our opinion, I shouldn't be here. The taxpayer should not have to be here. These letters should have been accepted at the lower level, and we shouldn't be here because it's so explicitly clear in the regulation. If that section of the regulation was not there, and we just came to the state with a letter, I'm used to this. I know they're not going to accept my letters. They're going to check my self-serving documents, unsupported, and that's what they're going to do. And that's usually what they do. In this case, they cannot do that. The regulation provides for these letters being sufficient documentation. They can't apply their normal routine to this letter. That's it. Thank you.
Mr. Mickey, could you please address the law section that the department asked about, 1671.1D4F?
Yeah, DF. 1671.1 D. D4F. Okay? Maybe, so 4F, routine audit. Okay, so what, is there a question? I mean, that supports my position, does it not? Does it not?
I just wanted to
Yeah, I mean,
clarify.
the only reason that, I'm sorry to interrupt, I'm sorry, go ahead. No concerns regarding the authenticity of the letter exist, since the subsequent verification establishes the rebate revenue was not paid in exchange for required reduction. The revenue is not part of the retailer's gross receipts. Is that not exactly what I'm doing?
Okay, so
Kinda
you're
wish I
saying
would've-
that that does support your position?
Um, At first read, I don't know why that's not exactly what we've done.
Okay.
If you think I'm missing something, point it out. I mean, I see.
Could you please clarify your position there with that regulation?
Not necessarily a position. He was just noting that letters and that rebuttable presumption really wasn't really noted, and I wanted to point out that there is an example here. The department's position in this case is that despite the fact we have a letter from the manufacturer, the other evidence we have indicates that the rebates were consideration paid to the retailer, and those are taxable.
Okay. thank
Same
you.
thing we said before. That's it.
Okay, thank you.
I would just say, I wish I'd have seen this section before. Because I don't know why that doesn't exactly say what I'm saying. 4 says, if you start at 4, the following are examples of transactional rebate and incentive payments are not included in the retailer's gross receipts. So that is what we're saying. These are not included. And the example here is that during a routine audit, the retailer is asked to provide documentation. However, the retailer does not have sufficient documentation. That is this department's position. To verify the revenue received from the manufacturer was not part of gross receipts, the retailer, us, we send a letter to the manufacturer requesting the manufacturer verify that the payment received under the promotional agreement was not paid pursuant to a contract requiring the retailer to reduce the selling price of the products. The manufacturer signs and dates the letter verifying this fact, returns it to the retailer. No concerns regarding the authenticity of the letter exist. Since the subsequent verification establishes that the rebate revenue was not paid in exchange for a required reduction in the selling price, the revenue is not part of the retailer's gross receipts. Oh, darn, I wish I had seen that before, because I would have been, I stopped at the law section, the first part that met my case. I believe that does satisfy exactly what we're saying. We have a letter. There's no question of to the authenticity.
Okay.
Yeah.
Does that conclude your rebuttal? Or would you have anything other you would like to add?
I believe would conclude my rebuttal for now.
Okay. CDTFA, do you have anything further you'd like to add? Okay, great. Judge Stanley, you have a question?
Yes, it actually came from Judge Long, so I won't take credit for it, but you didn't mention Boston Whaler.
Yeah.
What's the position with respect to that?
Good point. Okay, so with Boston Whaler, we acknowledge we do not have a letter on Boston Whaler. Boston Whaler, the Schock boats stopped selling Boston Whaler boats subsequent to all this. Boston Whaler was not cooperative in trying to help them do anything at all. They're selling competing boats right now, so we do not have the letter on Boston Whaler. Even at the appeals conference, we acknowledged that we didn't have the letter. Our point on that one would be that they're similar. So had Boston Whaler been able to give us a letter, it would have said the same thing. I acknowledge at this point, we don't have the letter. So Grady White is satisfied by the letter Boston Whaler would not be. There's 16,250 in the rebates that are Boston Whaler. You can't rule the same way for us that we have a letter on Boston Whaler, I acknowledge that. What you could rule is that there's similar types of transactions and the letter would have said the same thing. And we acknowledge that. But Grady White, there's no question. Grady White is supported by what the regulation says.
Okay, and there's no documentation in regards to Boston Whaler on
No.
the,
They were
no
we tried to get this-
promotional ads or
No.
anything?
No, the client didn't have anything at that point for that Boston Whaler, so it was kind of like, I went on the presumption, as, you know, audits often do, you look at a sample, and based on the sample, you accept the other things. We approached this Boston Whaler the same way all the way through the process. But we have no information on Boston Whalers.
Okay,
Just
thank
Grady
you.
White.
Judge Long, any other questions?
No questions, thank you.
Judge Stanley?
No, no questions.
All right, I'd like to thank the parties for participating today. The case is being submitted, and the record is now closed. The panel will meet to deliberate and decide your case. We will issue a written opinion within 100 days. Today's hearing in the appeal of sales by Schock is now concluded. OTA is in recess, and the next hearing will begin shortly.